Start. Greetings to the Honorable Justice of the Supreme Court of India. I am the counsel for the petitioner in this instant case of Win 11 and others versus the Republic of India. Counsel first and foremost seeks permission to collectively address the Supreme Court judges as Honorable Bench and individually as Your Lordship and Your Ladyship. Much obliged. The Council first and foremost humbly submits that the Supreme Court of India has the requisite subject matter jurisdiction to decide and entertain and execute upon this issue as per the Articles 32, 132, 136, and 142 of the Constitution of India. If the Honorable Bench is well versed with the facts of the case, the Council seeks permission to proceed with the issues. So, is in case. First is regarding the constitutional validity of the government of India's decision to ban the app. And second is regarding the NIA court decision to grant bail to Samir and Sohan, who are the residents who were eligible to have communicated with the suspected members of ISY. The rest two issues will be dealt by my co-counsel. So the first issue is regarding the constitutional validity of the app ban order. And the counsel for the petitioner answers this is in a negative. That is, the app ban order dated 1 May 2023 is in fact not constitutional. Counsel for the petitioners have approached the Supreme Court because of the decision of Osmania High Court decision to stay the effect of the app ban, but all stay orders on any proceedings by any court, including the High Court, have a feature that they automatically expire within 6 months. So what the petitioner seeks, that is Win 11, is the complete bashing or the quashing of the app ban order by the government. The first issue as to how it infringes Article 14 of the Win 11 is because the action of the government to ban the apps is manifestly arbitrary. The council requests the judges to direct their attention to the memorial page 19. Paragraph 12 of page 19, it has been given what exactly constitutes a state action that is manifestly arbitrary. A state action is manifestly arbitrary when it has been brought out irrationally without taking into consideration adequate principles, and it also includes within its purview actions which are excessive and disproportionate. How the app ban order is excessive or disproportionate is because of 4 reasons. First, the include app ban order banning Win 11 which is predominantly a gaming app, just because of its chatting feature, is a disproportionate action on the part of the government. The government could have taken much more appropriate measures instead of banning the app in its entirety. The second reason is that there is no proof of information about the contents of the communication as to how the communication between Samir and Sohan with the suspected members of ISY in any way pose any national security threat to the national security of India. Third, the council requests the Honorable Bench to direct the attention to the fact sheet, paragraph 2. MOOT proposition, paragraph 2. Stated, are you with me or second with me? MOOT proposition and paragraph 2. It has been stated and it's highlighted that the government relied on suspicion before banning the app. The government did not do any preliminary investigation of any sort, and instead, just basing its opinion on its suspicion, it banned the app. The fourth reason is stated in the MOOT proposition, paragraph 3. Highlighted portion clearly states that Win 11 and its businesses are completely legitimate by the many judicial pronouncements of India. And thereby, council submits that the action of the government in banning the 8 apps, including Win 11, is a highly disproportionate one. Hence, it is manifestly arbitrary. Council also submits that furthering on the point of how the government could have taken the decision in a much more appropriate manner, instead of banning the app in its entirety, is that it could have mandated security verification login of any user, or it could have, for starters, only banned those accounts in the app that were actually under scrutiny. But it went on and banned the whole app, which is played by which is played nationwide by all the residents of India. This not only resulted in the losses of entertainment industry, but also to the entertainment of the and also to the Win11 itself. The second argument in this issue is dealt in page 21 of the memorial. With me, Lordship and ladies. But to apply. The second argument that the Indian app ban order uh, violates the concept of safe harbor, which is a well-established principle in the IT Act. If the honorable bench can direct their attention to para 17 of page 21 of the IT Act, and in this case, as Win11 is, translates an electronic record or provides any service with respect to that record. In this manner, of Win11, Win11 is clearly an receipt and storage of clear data on an electronic record. Section 79 of the IT Act states that intermediaries such as Win11 in this instant case are exempted from any liability. For your further reference, can I please direct the honorable bench to turn their attention to compendium page 24. What exactly constitutes section 79 of the ITS? Communication is the chatting between surveillance phone and suspected members of ISY. Simply because the function of intermediary is limited to providing access to a communication system only. Also, the intermediary does not initiate the transmission because Win11 does not decide who plays their game. Also, it does not have the liability if it does not select the receiver of the information. In this case, Win11 did not select. It's humbly submitted that because of the concept of safe harbor, which the government has clearly violated in this present case, the government has made an erroneous decision in banning the app. Last argument in this issue is dealt in government in banning the app has not met certain statutory as well as procedural mandates that are crucial for blocking any content. Although Section 69A of the IT Act empowers the government to block any content, but the content's procedure has been laid out in the IT rules of 2009. It said that before blocking any content, there has to be a normal route or an emergency route. This is and it government has to follow by bringing in the relevant authorities in place so that the government section is not deemed to be case. It is not stated neither in the factual matrix nor by the decision of the government. So the public does not know the government exactly take. Hence, it is submitted. It is submitted that the government in banning the app has not brought in knowledge whether it has followed the procedure or not, and if it did, what procedure did it follow? Council seeks permission to rest issue 1 and proceed with issue 2, means about the special NIA court's decision to grant bail to Samir and Sohan. The petitioner submits that the special NIA court has indeed not made an erroneous decision in granting bail to Samir and Sohan, and this will be proven. This will be proved for Samir and Sohan. If the honor Second, if Samir and Sohan had either the intention or the knowledge of whom they were communicating with, and that what is the UAPA Act to which they have been charged. Government cannot simply arrest, and it has to show, the government has to show more on its part through which reasonable grounds have they arrested Samir and Sohan in the first place. And a special NIA court who deciding this has granted bail to Samir and Sohan. Honorable bench can direct their attention to page Honorable bench is Gautam Navlekha versus State of Maharashtra, which was 2021, in which it was stated that intention is a crucial prerequisite for proving an offense or even attracting the provisions of UAPA. The second argument is in the same line that there have been no acts of violence or even incitement of violence, and there have been no terror attacks due to the suspected communication between Salman Sohan and the ISYS members. For proving any offense in UAPA, it is a must that after the alleged charge, there has to be any acts of violence, advocacy of violence, or even incitement of violence, the three of which are clearly absent in this case. The Special NIA Court was rightful in its decision to grant bail to Salman Sohan. The last argument in this issue is a pretty logical one. If the honorable bench can direct their attention to the fact sheet, paragraph 3. Last line of paragraph 3, it has been stated that the government, after banning the apps, decided to give the proceedings to the NIA, which in itself is a wrongful decision. It go by, NIA started the investigation, but it was the same NIA who granted bail to Samir and Sohan. If you think about it, and the UAPA state that if there are prima facie true evidence then the bail cannot be granted. That is the presumption of guilt in the UAPA bail provision, but is the fact NIA still, after assessing the merits of the case, decided to grant bail to Samir and so on. That is in itself sufficient to prove that there was indeed no reasonable grounds or prima court's decision is respected also for the petitioner. The Honorable mentions any doubt on any issue, the counsel for the petitioner welcome to clarify. Uh, Counsel seeks permission to conclude with the issues 1 and 2 and hand over the podium to my co-counsel who will be dealing with the rest two issues, issue 3 and thank you. It was an honor arguing before you. Thank you.
Honorable Chair, extension will deal with the issue number 3 and issue number 6. Number 3 talks about the extradition request filed by the government of India is valid or not, and issue 4 deals with the constitutionality of notification dated on 3rd May 2020. If the bench is well versed with the fact of issue 3 and issue 4 can the constitution with the issue number 3, my problem. The council submits that the extradition request filed by the government of India is invalid. It will be explained in 3 ways. First, Mr. Roy is booked under Section 40 of Section 4 of PMLA. Section 4 defines the punishment for money laundering. Money laundering is defined under Section 3 of PMLA. According to the Section 3, intention is essential elements for pleading the guilt under the offense of money laundering. As for the statement of fact, para 3, point 3, stated that Mr. Roy was found responsible for developing an algorithm. But it is nowhere stated from factoring matrix that Mr. Roy has used that developed algorithm and he mainly transferred the money to the ISIS group. The word knowingly is important because as per the section 3 of PMLA, it states that a person can knowingly assist, can knowingly be a part, if he knowingly involved in act and process which leads to proceed the crime. So moving on the second point, as stated in the statement of fact, para 2, 9456, para 2, 9345. It stated that when element is not listed in Apple App Store in Google Play Store. So any option left with the general public to download the app is a third party link which is vulnerable to cyber attack. Therefore, there is a case that third party might have used that algorithm and win money to winning mega tournaments and diverted that money to the ISIS. The third argument is that Mr. Roy is also booked under Section 40 of regulative. The bench can divert the attention to the companion page number 8. Council request to read the section lines. Offense of raising fund for terrorist organization. A person commits the offense of raising fund for a terrorist organization who with intention to further the activity of a terrorist organization. The word intention is essential because in the present case, from the factual matrix, we cannot assume that there was intention on the part of Mr. Roy to fund a terrorist organization. Therefore, Mr. Roy is not liable under Section 4 of PMLA and Section 40 of UHCS. Therefore, the fund was not from the either. It was 700 crores. Looking into that as an what is yours? So total was not transferred some of the amount out of 700 crores which was not defined as transfer to the ISIS base. The intention of Mr. Roy cannot be assumed. Yes. Yes, okay. I remember. Yes. Understand. Okay. The government has given new chance to take action before taking action to like a ban the yes. Yes, the government doesn't have as as there is a transfer of money. So what action was initiated from your end? Around that is municipal responsible for people current seven taxes. Where the user gets the 11 therefore turn to download to the to external third party links which are vulnerable to cyber attacks. So if it is vulnerable to cyber attacks then you start the movement of funds onto safe player as in see. That's if you have 700 states for a time of 5 years, isn't it? So if you listen to the division, then we figured out that this transfer of money from that size, then your taxing regulation is 10 years old. So, the Google 11 app, Google 11 app, never tournaments was manipulated. The money is transferred from bank accounts to bank accounts. It's can only bank account, the bank account, biggest bank, the biggest bank. Yes, intensity. It was the findings of the NI. The company has not found out about the transaction transfer of money. This is something that's the finding the NI. That is why we have a CD. 50 years that is not an interest. The factor matrix, the point of intention cannot be assumed. From the second, so, from the finding systems, from the first finding, it's current one, the third product. And the third product. We then talks about three without sending so the tapping communication is there. And the third part itself feature which you have highlighted is in the the downloading basing the active strengths and properties which are vulnerable to cyber attack. So in that case, the intention was there. See that you have highlighted it comes from regulator. Using transferring initiative service activities. And so the figures and 2011 app provides a tournament which was raised by the by Mr. Right and persons in which money was earned. If the app does not have knowledge about how the money is transferred to the meaning of money transfer because it is not run to the transaction on the app. And so need apps to not possible for the app to please have a look on the transaction. Therefore, council concludes that the acquisition which was filed by the government of India is invalid. If the bench is satisfied, can the council proceed with issue number 4?
Of the funds was also used for the coming of the ISYL. That's why we got this and which is totally being created.
We become the from sorry, it looks yesterday. To take an appropriate action.
Vanilla.
Yes. And by the NI, after the ban of the app, it was not possible for the app at the first place to take appropriate measures. The action has to be before the that will serve some concern. So immediately, administrators from your own that will be initially important. So we have convinced so that you give a point of view of a general acts. In the first place, so the inquiry or the information about these transactions and all these things was given by NIA after the banning of the app. So even after the banning of the app did not have any chance to take appropriate action and stop this method. Mother. So who talked about the constitutionality of multiplication dated on 3rd May 2023. 23 increase the ambit of relevant persons and increase CA, CS, and CWA under the ambit of relevant persons. Relevant person is defined under section C SA of the PMLA. The bench can direct the attention to the page number 14 and then. Here the experience relevant persons carrying a business of property. Have a chance to fill this? Mr. Page. Persons. No persons. For the page 5 of the sequence of facts, the work of relevant person was given. The 5 points were given first, buying and selling of any immovable activities, management of client money, securities and other assets, management of bank, savings and securities accounts, organization of contribution for the creation, operation or management of companies, creation, operation or management of companies, limited liability partnership or trust, and buying and selling of business entities. Classification and the present case. The regional classification was the test of regional classification was given to the case at state of West Bengal was Anwar Ali Sarkar, in which an essential element is that there is a rational axis between the object of the legislation. There is a rational axis between the aim of the legislation and the law and in the present case, the aim was to summon only Mr. Prey because the notification included with clarity. But the government only summoned Mr. Prey, which shows that the meaning of the notification was to summon Mr. Prey. Therefore, there is no reasonable, there is no rational access in summoning only Mr. Prey and not the CS and CWA of Mr. Roy. Only test of proportionality, which was laid down in the case of CS Krishnaswamy was a criminal offence. According to that case, an essential feature for proving the test of proportionality that there should be an alternative measure exists. That there should be no alternative measure. But in the present case, the government, through the RTI filings or income tax department filings, can see the Appendix sheet number 33 and 34. Initiated legal petition filed by the Justice C.S. Suttapani, retired judge. We are challenging the Aadhaar 26 EIDAI number and Aadhaar, and this unique number was given to each and every citizen and it was used for welfare schemes. The constitutionality of this was challenged in the Supreme Court and see that is these rights to privacy of an individual. And either the validity position, either the validity position. 833 highlighted question point C, the extent of such interference must be proportionate to the history of company. of such independence must be proportionate to the need of such enterprise. In this case, the government, without interfering in CSUS, firstly could have made a procedure first to go to the RTI filing and see the report transaction history, and then if they require anything, they can summon. But in the present notification, there is no procedure except of first dealing with some procedure. According to notification, the government has power to directly summon CSCA and CW. The C means follow. Finder has given it to the open state and investigation. RTI filing can be immediately be at a place, and government can easily see the RTI filings about the transaction history. Summoning PS and PSWA will take time. RTI filings can be done immediately. At the first the procedure will be laid down. First, some steps will be taken to do the transaction, and if something is unclear or something is not working, something is submission. National security is a concern in the present case. This notification will also be valid after the case is over. So it will be a lifetime liability in all the three processes. Point number 3 about the government has acted arbitrarily in giving out this notification. On 2nd of May, NI court has given the judgment on basis of the inquiry of the NI inquiry done by the NI court. So according to 1550, the inquiry was done. Therefore, now the power after the second judgment, now the power rests with the adjudicating authority according to section 11 of PMLA to investigate on the to give command to investigate on the further case. The government, by giving the notification, has acted ultra vires. Fourth point is that the notification will bring extra burden, issue burden on CHUS and CWA entirely. CHUS and CWA will be responsible for each and every transaction done by their client. There can be a cases of false, false laundering cases, and they will be responsible for summoning each and every time when there is error in the transaction history or from the side or there is mistake from the side of the client. The council is talking about in generality that there can be cases of false. So, no, the case of this can cannot be generality. Policy to proceed to the trial. Light of the measures at the issue, legal theory, even given an authority cited, the counsel for petitioner respectfully request the Honorable Supreme Court first to declare that the notification of banning an app is invalid. Second, NI Court has not erred in granting bail to Samir and Shivam. Third, the extradition request filed by the government of India is invalid. And fourth, the notification dated on 3rd May 2023 is unconstitutional and pass any other order at a deemed seat in interest of justice, security and legal concern. So, much honor arguing before the Honorable Supreme Court.
knowledge the graphic presence of your leadership, but for the community of argument, this is permission to address the bank collectively as a life. This permission is the discipline. Your lordship, the present fact, your lordship, the brief fact is that on 1 May 2023, Winning was banned, and on 6 May 2023, interim order was granted, interim stay order was granted on the operation of this ban, the order dated 1 May 2023, and that order was signed by the respondent, that is us. We are from the Union of the India, and we have signed this under 132. And issue number 2, MIA court has granted bail to Samir and Sons, and that we have also challenged before your lordship under Article 132. And your lordship, the petitioner, according to their submission memorial, has challenged issue number 3, the appeal against the High Court granting the extradition which is under Article 136 and the notification dated 3 May 2023, 3 is under Article 132. But your lordship, the petitioners have not stated which order they have challenged with Article 136. So our submission regarding this jurisdiction, if your lordship may permit, come to the science to proceed with the argument. Your lordship may apply. The issue number 1 and 2 will be issue number 1 and 2 will be Beltrami, and issue number 3 and 4 will be Beltrami. So comes in issue number 1, your lordship, we have government of this India have banned the general application on 1 May 2023 on the suspicion that it was used by some terrorist organization for communication and subsequent attacking Azhar crimes. And on 6 May 2023, High Court of Islamia has granted interim stay order on the operation and effect of this order through an interim order. This interim order we have challenged under Article 127 of the Constitution. So the whole argument of this case will be within the limits of Article 132. That whether the interim order granted in favor of Union application was justified in the present case or not. So, your lordship, we granted interim stay order as such that there are 4 grounds for lordship. First ground is whether the prima facie case is clear. Second ground is balance of convenience. Third ground is irreparable harm and injury. And fourth ground is considering sex as public injury. So in the present case, your lordship, our submission is that all 4 grounds are made in favor of Union of the. So with regard to the prima facie case ground, your lordship, prima facie case means that whether the prima facie case is made out in exercise of its powers under section 69A of ITF. So your lordship, if your lordship has section 69A of
that what were the reasons with the government to ban the application? The reasons were before the court. You cannot say that you cannot hidden the reasons. When we are requesting you to see what is the reason for the government to put ban of the application. Okay. So how it could put it on court. Concerning that you can restrict yourself. You cannot publish before the public that what were the reasons. But we are asking you to put before the court what were the reasons that you have put ban of the application.
Reasons. First, there was a suspicion on.
Correct.
That's why we banned. After banning the suspicion, we have
There must be satisfaction on your part and the duty of the ITS.
that is fair and
There must be satisfaction. That activity continued by the petitioner is necessary to be or expedient to be in the interest of sovereignty and integrity of India. What are the reasons? It is related to sovereignty of India.
yes, that is our reason. I will mention on the ground the interest of sovereignty, integrity of India, defense of India, security of the state, and friendly relations with foreign states, public order, so and so. So here the grounds are interest of sovereignty and integrity of India are made because the offense are of terrorism. Second is that the defense of India, security of the state. All three grounds can be banned on all three grounds.
Because correct. These are the grounds to put ban or information is run by the BJP. But there must be some material available with the government that the security of the nation is damaged, security of sovereignty is damaged. Yes, what are the material available with the government?
The material through various channels were launched. And that is a question, the evidence has to be laid to prove your lord.
We think also we can request you that you
Your lordships, we have the requisite computer engineer and technical team to assist your lordships in that matter. But that matter is pending before the High Court, and your lordships have not transferred the case to itself before the court. The matter is only limited on the
by NIA, it must be available with the prosecution that now this material is available. And therefore the sovereignty of India, the central government or the state government has thought it fit to put ban.
So the lordships, UAP investigation was handed over to the National Investigation Agency. National Investigation Agency has arrested Samir and so on, and their investigation is going on. The lordship. They have been granted a bail. In the third issue, Mr. Roy has been found to be manipulating the vanilla application and diverting the fund. So we have the NIA has conducted, and we have the material, and this is not the stage to put the material, and because the argument is limited to this, and our contention is that
From the prosecution,
we respond to this.
you are covering the government,
Yes, Lord.
you are appearing from the Union of India. Correct? Covering the investigation also. That whatever investigation was carried out by the NIA or investigating officer is correct and right. Correct? So you have to collect all the materials from the why you are suppressing material.
We are not suppressing our submission. We are not suppressing. We will present it, but we have to leave the evidence to satisfy it. But
It's a matter of trial that what evidence was made by the person.
so that is not like the lordship submission is that under section 69, satisfaction has to be based on some suspicion. Suspicion means that there has to be reasonable ground to suspect. Suspect can be made. Their first thing happened, your lordship, that there was a communication was done for this particular application, and there was subsequent
Behind the source here, question is having reasons.
the reasons is that terrorist people were communicating through this mineral application, and there was subsequent attacking Ozark Bank. That was the reason to ban it. And after the banning, NIA was conducting the investigation, and NIA has found, firstly, Samir and Sohan were communicating through this mineral application. So, investigation.
It is the case of the prosecution or the government basing the oral statement or the allegations made against the petitioner. That he is connected with the terrorist activity or he is using some kind of activity.
Yes,
But what material is available with the court?
the material available, your lordships, in the investigation regarding survey and so on, the mobile phones are sufficient. Your lordships, they have got the information through some intelligence department. Your lordships. So let's say defense and other material. Let's say NI has got the information on the suspicion. Your lordship, the section 43A, if your lordship permit, of UAP. Yes, sir. Regarding the issue whether Samir and Sohan were arrested was justified is the issue number 2. Samir and Sohan were arrested under section 43A. Section 43A, the ingredients of section 43A, any officer or of the designated authority empowered in this behalf by general or special order of the central government or state government, as the case may be, knowing of a design to commit any offence under this act or has reason to believe from personal knowledge of information given. So in the present case, the NI has been empowered by the central government. So the NI, if there is a design to commit and NI suspect from any material, if there is a design to commit from any material available, whether the knowledge has been gone through any channels, he can be arrested. They can make an arrest under section 43. So only the grounds are that if there is a suspicion that on the based on material, they can be arrested. So they have been arrested under section 43.
My question was why you are attempting to put on record before the court confidential. You cannot declare the other side that these are the materials available in the prosecution or the government. But I am asking you in the court that you please put on record that what are the materials available with the prosecution or the government to ban the application of the petition. So this section 43 relates to the powers of the officer to arrest and search for the property. There cannot be denied that no powers are given to the officer to search the premises or the property, to arrest the suspected person. You may done it.
So answer the question that our expert engineering team have examined the servers in the Ozark Valley where the attack has happened, and they have found that the Win11 application, which is a fantasy game application, has been used by the terrorist organization to commit the terrorism. So the expert team have examined, and we have got the knowledge from that expert team. So after gaining the knowledge, we have first banned the application because the communication was done through this, and there was high chances that it could be misused again. And after this, we have given the representation. Then, so your question again coming back to the question, answer of your question, your question.
Answer.
One last time, I will address what I can. One last time.
Available with the prosecution or the government that it was necessary or expedient or it was damaging the sovereignty of the country or the nation that you are compelled or your decision is taken by the government officer that the application of the mobile should be banned. Your expert team of the computer has found something from the application that the activity of the petitioner is doubtful to the sovereignty of the nation or the country. Correct? And on the basis of this information or the material found by the expert committee, decision was taken accordingly as per rules under section 69A of the ITF, following the rules. But my question is that what material was available with your expert committee, you can put before the court. So kindly direct your attention to this. Fantasy gaming platform, the power of fantasy.
Lordship, your Lordship, it is stated that it is still restricted to list application of Google Play and Apple Play Store, and the users of Win11 application are therefore constrained to download and update their app to external third-party links, which are vulnerable to cyber attack. The first thing, Your Lordship, they are not available on Play Store or Google Store. That's why it makes it more prone to cyber attack because they have to be downloaded to external third-party links. That is the first case, Your Lordship. The people of the country are using this application from third party, which are more prone to cyber attack. The first ingredient to suspect. Second ingredient, Your Lordship, Mr. Frame, Your Lordship, has been manipulating this platform since 2018 and has been collecting money through this application, Your Lordship. Because the credibility of this, the security standards of this application are not built. That's why the application has become exploited by a single engineer, computer engineer, and to collect 7,000 crore rupees and to divert it to dubious account and commit terror funding. So these two grounds are sufficient, Your Lordship, to ban the application as per the section 69 is concerned, Your Lordship. So after this, Your Lordship, whether the material will justify will be conducted in trial, Your Lordship. But this material itself is sufficient for taking action under section 69 because it only empowers to take action on suspicion and reasonable grounded suspicion. So, Your Lordship, to say, Your Lordship, so Your Lordship, with the final submission, Your Lordship, that the High Court interim order was not justified. Your Lordship, memorial text. Compendium case, Your Lordship. I have cited. The Lordships are between two compendium. Page number, flag number 2. Your Lordship. Assistant Collector of Central Exercise. That's right. So, flag number 2 is there. So, para number. We repeat and deprecate the practice of granting interim stay order, which practically gives the principal relief sought in the petition for no better reason that the prima facie case has been made out, without being concerned about balance of convenience, the public interest and host of other relevant consideration. Regard the practice of some clever litigants of resorting to filing writ petitions in far-away courts having doubtful validity. So the court has shown concern in the present situation. Whenever there is a consideration of public interest has to be taken while granting citizens waivers. A strong case has been made against waiver application, and the High Court ought to have not granted interim stay order in this preliminary state, and how to have whole and then concluded the matter because the relief sought by the petitioner is of the nature which gives practically gives the final relief. So my issue, I will conclude my issue with this submission. What were the issue for this? So issue is given in para 7. So Judicial India Limited is a manufacturer. Your Lordship, the brief case is that such. Now coming to the facts of the present case, the respondent Judicial India Limited is a manufacturer of tire tube and various other rubber products. By a notification dated April 6, 1984, issued by the Government of India, Minister of Finance, in exercise of his power conferred by Rule 8.1 of the Central Exercise Rule 1944, tires falling under item 16 of first schedule to the Central Exercise and served at 1944 were exempt from a certain percentage of exercise duty to the extent that the manufacturer had not availed themselves of the exemption granted under other earlier notification. The department was of the view that company was not entitled to the exemption as it has cleared the goods view that company was years earlier without paying central exercise duty, but on furnishing bank guarantees under various interim orders of the court, the company claimed the benefits of the exemption to tune of rupees 6.5 crores and filed a writ petition in Kolkata High Court and sought an interim order restraining the Central Exercise Authority from levying and collecting exercise duty. present matter was such, Your Lordship, that the revenue, the right of the defendant to collect the revenue was set there, and the petition approached the Kolkata High Court, and Kolkata High Court granted in their term. So that was the case, Your Lordship. And it was held that it was against the High Court has not considered the fact of public income, because it is a matter of collection of state revenue versus the profit making of company. So, whether the special NI court Usmania was heard in granting bail to severance or under the code. So the facts are such, Your Lordship. After banning of the mineral application, some NI has conducted the investigation, and after conducting the investigation, the NI has found that two residents of Usmania, Samir and Soman, have been using this application mineral level to communicate a suspicious member in Ozark Valley, and he was a member of a banned terrorist organization as well. Hence, they were arrested under Section 43A. So, 43A, if your lordships have given to you. On Section 43 of the okay. The Section 43 gives power to arrest and serve. The ingredients have already mentioned about it. If the central government authorizes an investigation authority to investigate, the investigation authority on mere suspicion that there is a design to commit an offence under the UAPA, they can arrest the lordship. So in the present case of lordship, the NI has been entrusted with the investigation by the central government. So the duty of NI was, whenever there is a suspicion that the offence under this act will be committed, there's a design to commit offence, it is the duty of the NI to act accordingly, to arrest. So the Section 43 is a special legislation which gives the power to prevent before the happening of the offence, to arrest them. So they were arrested under Section 43 of lordship, and after the arrest of lordship, their suspicion is based on well grounded. First, the Samir and Sohan were using
The section I think further. Person has committed an offense punishable under this act or from commission of such offense or from any acquired property. And so you have to satisfy them what exactly the earlier question with yes, yes. Before you. Yeah,
that is why I was to cover the issue second. That's what is happening. I was supposed to cover the issue number 2.
please.
Then issue, Your Lordship. Samir and Sohan, if Your Lordship come and fact you, the Samir and Sohan were using the mineral application for chatting with some suspicious member in Ozark area. First, Your Lordship, they were using the application which was alleged to be found used by the terrorist organization to communicate and attack the Ozark Valley. So first, they were not using any application, but this particular application will enable. The first point. Second point, Your Lordship, they were communicating with some suspicious member belonging to a banned terrorist organization. So there are many terrorist organizations and there are many suspicious members, but they were communicating with the suspicious member who was in Ozark Valley. So he was the member present in Ozark Valley. That's was the second condition. So they were communicating through the application which was suspected to be used by terrorist people as a convenient method to communicate. Second, they communicated with a member who belonged to Ozark Valley, and that was the second contention. So that is why the NI has sufficient justification to arrest them under Section 43.
Thank you break to this two persons.
Your Lordship,
The error was there, discretionary powers are there, lying with the High Court, under Section 439 of the Criminal Procedure Code.
there is clarification. Your Lordship, that
Discretionary power.
NI has granted.
Correct.
High Court has granted.
Court has granted the power.
Yes, Lordship.
Court has exercised the power.
Yes, Your Lordship.
Section 439 of the CRPC.
No, Your Lordship. Under the weight, yeah, this is a special legislation. So the power to grant bail, the section 43D. The bail was granted under section 43D of bail. I have the judgment of person. The UAP is a special legislation, unlike other criminal legislation. So the conditions of bail under UAP are stringent, unlike other provisions of any criminal act. So the condition of bail under UAP are strict, and court has to be prima facie justified that the offences alleged against the accused are not true before granting the bail. So our contention is that the court has failed in their justification to grant bail, because the prima facie case is made out in exercise of section 43, as I have mentioned, the exercise of power under section 43, because there was strong ground to suspicion these two people, because they were communicating through a bank communicating to a mobile application which was alleged to be used by tennis people, and then they were they were communicating with the member which was present in the Ozark Valley when the attack was happening. So, your Lordship's kind attention to the judgment of NI versus George R. Badal on 5/5. On para 24, related part, relevant part to save the time of this program. The Vatali limit state, your Lordship, para 23. The Vatali limit state, your Lordship, by the very nature of the expression, by the very nature, the expression prima facie would be that the materials evidence collected by the investigation agency in reference to the accusation against the accused concerned in the first information report must prevail until contradicted and overcome or disproved by other evidences. On the face of it, shows the complicity of such a accusation in the commission of the state. It must be good and sufficient on its face to establish a given fact or chain of facts constituting the stated offense, unless rebutted or contradicted. In one sense, the degree of satisfaction is lighter when the court has to opine that the accusation is prima facie true, as per the opinion of the accused not guilty of the offense as required under the other special enactments. So, degree of satisfaction is very low. The investigation agency has to prove on the base chain of circumstances that they were justified to arrest the surveillance soldiers, which has been proved in the present case by this chain of circumstances. So, because of this special legislation NI, unlike other jurisprudence, the bail jurisprudence doesn't apply, because this is preventive law, preventive of terrorism law. The legislation has given special power to the NI. Now, your Lordship, I will take, if they have been granted bail, what will be the consequences of if they have set free of the bail?
Next, you say that it's they are satisfied that there is no time of this yet.
They are not mentioned on which date they have been arrested and on which date we have uploaded this provision. So this is our
See the chronological order. Before you charge sheet him when
charge sheet has not been filed. Investigation is still going. Absolutely. Proposition states that the two users, Samir and so on, resident of Usmania, a state in India, have used Vanilla, which is a chatting platform for communication with suspicious members in Ozark Valley who belong to a banned terrorist organization as wise. Hence, they were arrested under section 43A of the US. And there is no mention of charges. And then later, based on opposite factual scenario, 3 points. Samir and so on has been granted bail under section 43 of UAPA by special enactment. So the 2 points are, there are only 2 points in the package regarding Samir. Rest of the facts are irrelevant in the present case.
For detained who not to raise the evidence very quickly, but to have it hanging on the basis of the strong probability. What has not to meticulously go to the evidence of the prosecution.
Power was under section 14. And 43, I will just take 2 minutes.
I'm not doubting so far the power stability officer, power government that your a doubt, strong doubt against the petitioner that they are involved in such kind of illegal activities of communicating with terrorists, creating some funds for the enemies of the whatever they do.
Even the proposition is silent on that aspect when they were arrested. So we are assuming that they were the investigation is still going on and the charges are not framed against them. The reason why they were arrested was only ground that they were to commit a terrorist, they were to commit an offense under this act. There was a suspicion they will commit an act. That was they were arrested. First ground under 43. So the investigation is still going on. We will file all the charges and will submit a charge sheet in the case. So while conducting the investigation, he has approached the court and court has granted bail in this situation. So while granting the bail, when this investigation is still going on, there is some duty on the court.
Isn't it 10?
That is different information because they were differently charged and different investigation is happening throughout the investigation. So all issues are isolated in aspect. So the accused Samir and Sof were granted bail by NI court while the investigation is going on. And they were only arrested because there was desire to commit offense. There was suspicion. So it was the duty to first prima facie evaluate the evidence of the court. We have established the chain of events why the suspicion was well grounded and the arrest was justified. And now we will deal with the consequences of bail violation. That is the second consideration why the court has to be considered while setting the accused on liberty. The consideration of such your lordship. If the first thing is your lordship, the accused will not commit an offense while he is on bail or repeat the offense. That is the first condition. The condition is in the present case, your lordship, there is a high chances that accused will repeat the offense because the modus operandi, the mobile use and proof video application online, and the investigation agency cannot monitor him while he is on bail. So there is a high chances that he will communicate with other members of the OSAR, other terrorist members, and repeat the offense. Second, your lordship, there is a high chances of tampering with the evidence because of this modus operandi itself. Your lordship. Third, your lordship, there is a high chances that he will expand the territory of your lordship because already one person has expanded. Your lordship, there is the possibility of this expanding cannot be excluded in the present case. So, your lordship, the present case situation is of public interest versus the individual liberty of a person. And hence, in the present situation, the NI was justified. The the order of granting bail by the NI special court was not justified, your lordship. And NI investigation agency was justified in arresting Mr. Roy under section 43 of that is of the that is our condition. Lordships have no further question. It was honored to argue.
To proceed to the much of that.
issue three is whether the extradition request of Mr. Roy, which has been made by the government of India and the said request being granted by the 2nd May 2023 and being upheld by the High Court of Virginia on 10th May 2023 are valid for law. Our submission is that the request is perfectly valid and it is according to the procedure. The procedure and Dependia is governed by the Extradition Act of 1962 as well as the extradition treaty signed between both the nations. According to this treaty, court's conditions need to be satisfied for a person to be extradited from one country to another. The first is that the offense for which he has been requested must be an extraditable offense. Second is that the principle of dual criminality must be satisfied. Third is that the prima facie case against Mr. Roy must be against the requested person must be made up. And lastly, that he must not be accorded a capital punishment by the requesting country. Conditions are satisfied in the present case. Now, your lordships, the first condition is that the extradition request must satisfy the principle of extraditable offences. Now, if your lordships are at Article 2 of the said treaty, it defines what is an extraditable offence. Now, Article 1 states that an extradition offence for the purpose of this treaty is constituted by conduct under which the laws of each contracting state is punishable by a term of imprisonment for a period of at least 1 year. Now, in this present case, Mr. Roy has been requested for the offence of raising funds for a terrorist organization and the offence of money laundering. These both offences bear a punishment of both requesting country as well as the requested country. Therefore, the first principle is satisfied in the present case. The second principle, that is the condition, is that the principle of dual criminality. Now, this is a very basic principle. And it is found in extradition treaties all over the world. According to this treaty, the act for which the requested person is requested, it must be an offence in both the offence under the laws of both the requested as well as the requesting country. Now, the offence terrorist organization is an offence under the Unlawful Activities Prevention Act, and as per Section 40, and the offence for raising same two acts, the same two offences are also in the legislation of the United Kingdom. Terrorism Act of 2000 and the Proceeds of Crime Act of 2002. Therefore, the acts for which Mr. Roy acts satisfy the principle of dual criminality. Now, the third condition is that the prima facie case must be made out against the requested person. Now, again, repeating that the two charges against Mr. Roy are of Section 40 UAPA, which is offence for raising funds for terrorist organization, and Section 3 of the PMLA, that is offence of money laundering. Now, I would like to draw your lordship's attention to Section 40 of the United Unlawful Prevention Act. The prevention of money laundering has been given, but I'm now referring to the Unlawful Activities Act prevention. As for the reading of Section 40 is as follows: a person commits the offence for raising funds for a terrorist organization who, with the intention to further the activity of a terrorist organization, A, invites the other person to provide money or other property and intends that it should be used or has reasonable cause to suspect that it might be used for the purposes of terrorism, intends that it should be used or has reasonable cause to suspect that it might be used for the purposes of terrorism, or C, provides money or other property and knows or has reasonable cause to suspect that it would or might be used for the purposes of terrorism. Now, the prima facie case against Mr. Roy has to be made out. Our submission is that Mr. Roy has created an algorithm. Now, that algorithm has been used to win tournaments on the win level application, and then the money which has been won from that tournament terrorist organization. Therefore, Mr. Roy knew by creating that algorithm that the money which will be earned through this. Therefore, our submission is that prima facie case is made up against Mr. Roy, as per Section 40 of the Unlawful Activities Prevention Act. Now, the second charge against Mr. Roy is that of offense of, according to Section 3 of the Prevention of Money Laundering Act, it states that whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use on projecting or claiming it as untainted property shall be guilty of the offense of money laundering. Now, the terminology used over here is the proceeds of crime. Proceeds of crime is defined under Section 2, subsection 1, clause U of the PMLA. It is defined as any property which has been derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Now, PMLAs are scheduled. Under the schedule, there are various paragraphs dealing with offenses under various deals with offenses under the Unlawful Activities and Prevention Act. Under that para, entry 15 is the offense of raising funds for terrorist organization, which is Section 40 of the Unlawful Activities and Prevention Act. Therefore, it is submitted that the prima facie case under Section 4 of the PMLA is also made out against Mr. Roy. Now, the last person will not be afforded the capital punishment. Now, your lordships, the charge against him is Section 40 and Section 4 of the Section 40 of QAPA and Section 4 of the PMLA. Now, the statutory maximum which a judge can grant under this section is that of under Section 4 of the PMLA is that rigorous imprisonment of 3 to 7 years plus fine. Under Section 40 of UAP, it is not exceeding 14 years of or fine or both. Therefore, there is no chance of the requesting person, which in this case is Mr. Roy, being accorded a capital punishment. Therefore, our submission is that all the 4 ingredients as per the treaty have been satisfied in the present case, and therefore there is no ground for Mr. Roy not being extradited. Petitioners in their submission that like there is intention is an essential under Section 3 and Section 40 of the they were relying constantly on the intention part. Now, prima facie case is made out against these two, against Mr. Roy under these two facts. Now, if they want to proceed and if they want to defend the client, he must first be extradited to India and then he must face trial. And at the trial stage, they Mr. Roy. Prima facie evidence also points to the fact sheet state that Mr. Roy had created an algorithm. He winning Will 11 tournaments on Will 11 application, and that money has been transferred into dubious bank accounts. Our leadership had asked a question to the speaker of petitioners under which and they have admitted that the money has been transferred into dubious bank accounts, which further support our claim that Mr. Roy knew that the money is going to be used for the purposes of raising funds for a terrorist organization. Therefore, our submission, final submission is that all the 4 conditions have been laid out, have been satisfied in the present case. Yes, your leadership. Yes, sir. We agree that there has been some kind of shortcoming in the authorities in India because by letting Mr. Roy travel to United Kingdom. Now, I would like to draw your lordship leadership position to point page 1 of the fact sheet and the second point. It says that a computer engineer named Mr. Roy was found responsible for developing an algorithm which resulted in manipulating mega tournaments on Win 11 platforms and was thus charged for money laundering under Section 4 of the Prevention of Money Laundering Act for diverting 700 crores during financial year 2018 and 2023 as winning proceeds from various contests on Win 11 to dubious bank accounts. Some of these proceeds have been used for terror funding to IS and hence he was also booked under Section 40 of the UFPA. Now the next line states, however, before he could be arrested by the authorities, subsequent to the filing of the charge sheet, it was found that Mr. Roy has moved to the London. We agree that there has been some kind of shortcoming on the authorities in India by allowing him to travel to the United Kingdom. But this shortcoming on behalf of the authorities does not merit or does not take any issue or any does not the submission by the petitioners that Mr. Roy should not be extradited to India. There has been a technical irregularity and Mr. Roy was allowed to travel to the United Kingdom. If any obstacle or any meritorious point that he should not be allowed to give India to face a fair trial. So, if your leadership is satisfied with the answer, and if you have no further questions, Council seeks permission to proceed with issue 4. Our leadership issue 4 is whether the notification dated 3rd May 2023 enlarging the definition of relevant person under the prevention of money is ultra vires or repugnant to the Constitution of India or any other law in binding for court. It is the humble submission that it is not violative of the Article 14 of the Constitution. And a second submission is that expanding the definition of relevant person is a policy decision by the government, and there is very limited judicial review in policy decisions. Our first submission is that it is not violative of Article 14 of the Constitution. Now, Article 14 states that there, according to Article 14, class legislation is prohibited but not reasonable classification. Now, the Honorable Supreme Court in the state of West Bengal versus Anwar Ali Khan has said that the classification for a classification, 2 tests must be satisfied. First test is that the classification must be based on intelligible differentia, and the second is that that classification must have some kind of rational nexus or connection with the object of the statute in question. In the present case, the classification is that of the CS, and CWPs. The classification is of these 3 types of professionals. It is based upon the intelligible differentiation that these 3 types of professionals, persons, or these 3 types of persons are they are these types of persons which conduct transactions on behalf of their clients. And the object behind the statute in question is that the statute in question is the notification of the Government of India and the Prevention of Money Laundering Act. Now, there is a reasonable rational nexus between the classification and the object of the statute. Object of the statute was to increase obligations upon these 3 types of persons so as to provide critical information to investigating authorities. It was done to increase scrutiny. It was done to prevent proceeds of crime and bring transparency in transactions which have been committed by these persons on behalf of the clients. Therefore, these classification of these 3 kind of persons have a reasonable and rational connection to the object in the statute in question. Therefore, our suggestion is that it is not at all violative of Article 14 of the Constitution of India. Furthermore, our second suggestion is that the action of the Government of India is a policy decision. Now, your lordships, a policy formulating that policies come exclusively within the domain of the your lordships. I'll take only 5 more minutes to conclude with my arguments. But now, determining or examining a policy which has been determined by the government is not grossly irrational. Creating and implementing policies comes within the exclusive domain of the executive and in the fields assisting those assisting the government. Whereas on the other hand, the judiciary lacks the expertise in such subject matters. Furthermore, your lordship, that there are 2 cases which explain that the court should not interfere in policy decisions of the government. The first case is that of Directorate of Film Festivals versus Gaurav Ashwin, Jain and others. It is at flag 3 of the compendium. Yes. The brief facts in this case are that are given in of the judgment. Under the Cinematograph Act 1952, A film can be released for public exhibition only if it has been examined and certified by a central board of film certification as being suitable for public exhibition under the categories unrestricted or restricted to adults or restricted to members or any profession or class of persons. Your Lordships, at para 16, this Honorable Supreme Court has held that the scope of judicial review of governmental policy is now well defined. Courts do not as appellate authorities examining the correctness, suitability, and appropriateness of a policy, nor are courts advisors to the executive on matters of policy which the in this particular case, under the Cinematograph Act, was constituted of the executive government officials. Now they had laid down certain criteria which a film has to satisfy in order to be eligible for cinema awards. Now the filmmakers have in this case have challenged that the it violates Article 14 of the Constitution. The Supreme Court had refused to interfere because this was held as a purely policy decision of the government. In para 14 only, the last line, the third line states that the decision to consider for awards only those films which are certified by the board for public exhibition is a policy of the ministry. Further, your lordships, second case is that of Federation of Railway Officers versus Union of India and others. It is at flag 4 of the compendium. The next case. In this case, in para has observed in examining a question of this nature, where a policy is evolved by the government, judicial review thereof is limited. When a policy according to which or the purpose for which discretion is to be exercised is clearly expressed in the statute, it cannot be said to be an unrestricted discretion. On matters affecting policy requiring technical expertise, the court would leave the matters for decision of those who are qualified to address the issues. This is a policy decision of the government of India, which is backed by the objective of holding these three types of persons of not accountable but imposing an obligation upon these three types of persons. Therefore, our two submissions were that it was not violating of Article 14, and second, it is a policy decision. Therefore, the courts can only intervene in such matters if it is arbitrary or grossly irrational.
Can you please refer the notification dated 3rd May 2020 clearly?
Yes, it is at the last page of the fact sheet.
Explanation of this
In exercise of the powers conferred by subclause 6 of the clause SA of subsection 1 of section 2 of the Prevention of Money Laundering Act 2002, the central government hereby notifies that the financial transactions carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities. There are five activities which have been given: buying and selling of intangible property, managing of client money, securities or other assets, management of bank savings or securities accounts, organization of contributions for creation, operation or management of companies, creation, operation or management of companies, limited liability partnerships or trusts, and buying and selling of these business entities shall be an activity for the purposes of the said subsection. Now, explanation one states that for the purposes of this notification, relevant person includes firstly an individual who has obtained a certificate of practice under Section 6 of the Chartered Accountants Act. Second is that an individual who has obtained certificate of practice under Section 6 of the Company Secretaries Act. And last is that an individual who has obtained a certificate of practice under Section 6 of the Cost and Works Accountants Act.
by the government by issuing this notification dated 3rd May 2020.
types of these three types of classes.
Yes, yes.
No, it is not affecting. Because only an obligation is being imposed upon these three types of persons, not a liability. The petitioners in the submission have said that a lifetime liability will be imposed upon these three types of persons. These three types of persons have been included in the definition of relevant person. Section 12A and Section 12AA deal with the obligations which a reporting entity must perform. According to these are only the 11A states verification of identity by the reporting entity. 12 is reporting entity to maintain records. 12A is access to information and 12AA is enhanced due diligence.
Now you are expanding the scope of the given provisions incorporating these chartered accountants under the chartered accountants act under the 6 of the company secretary act.
Yes.
6 of the cost and works accountants act. The accountant act or under practicing receiving the certificate under section 6 of the company secretary act or under 6 of the cost and works accountants act. Why they should be liable for these offense buying and selling or
No. They are not at all liable. They have only an obligation to first verify the identity of the clients, to provide access to critical information, and thirdly, it was third obligation was that was the only penalty which or only penal liability upon these three types of professionals is that if they fail to perform their obligation, that is given in section 13 of the PMLA. It says that the powers of the director to impose fine. Therefore, only and only if they do not perform their obligations as a reporting entity, then only then they will be held liable, and then monetary punishment will be. Further, section 14 of the PMLA states that no civil or criminal proceedings against reporting entity, its directors and employees in certain cases. An obligation is imposed, and non
their individual right would not be affected by this scope of this certification issued by the government.
no, behalf of the clients.
By the government to make a transaction with the clients. By issuing this notification.
There is no restriction imposed. There is only an obligation imposed upon these three types of persons, because these three types of persons who are in charge of the transactions on behalf of the client. Now, this was done with the intention to prevent the proceeds of crime and bring transparency, and also to provide critical information to authorities who are investigating under the offense. Now, earlier, when they were not included under the reporting entity, they had no obligation. After they have been included, they have an obligation to provide records with extra information to the investigating authority. Subsection 1 of section 2.
It is section 6 of clause is A or subsection 1 of section 2 of the procedural. What is the modification?
Yes, yes. So, in the notice it states that the government has exercised power in the subclause 6 of clause SE of subsection 1 of section 2. Now, clause
Section 1
yes,
is A and subclause is
yes. Clause SE, person carrying on page 8,
8.
8 of the PMLA. Person carrying on designated business or profession means then there are 5 clauses, and sixth one is person carrying on such other activities as the central government may by notification so designate from time to time. I would like to draw your attention to clause WA, which is at the bottom of the same page, page number 8. It states what is a reporting entity. Reporting entity means a banking company, financial institution, intermediary, or a person carrying on designated business or profession. And designated business or profession has been explained in section SA. Section section 2, subsection 1, clause WA.
Reporting entity.
Yes. Including these 3 types of persons under 11%, they are included under 11 under reporting entity. And reporting entity states, and last line states a person carrying designated business or profession. Now, clause SA states what is a designated person carrying a designated business or profession. The clause SA 6 is a person who has been carrying on such profession from time to time as the central government may notify. So the government under this power has notified that these 3 types of persons will now be included under relevant person, therefore included under reporting entity, and therefore they will be the person carrying on. Therefore they will be the reporting entities.
Issuing is, I understood, some responsibility or liability is fixed by the government upon this being
Obligation is there.
obligation.
Obligations are given in section 11A, section 12, section 12A, and section 12AA. Can you proceed with the prayer? Therefore, in the light of facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed and implored by before this Honorable Supreme Court of India that it may graciously be pleased to hold that the action of the Government of India dated 1st May 2023 in banning Win11 application is valid in the facts and circumstances and cite the High Court interim order dated 5th May 2023 in favor of Win11 application. Hold that NI Court's order bail order for Samir and so on be set aside and that they be ordered to surrender. Hold that the extradition request of Mr. Roy by the government of 2023 and 10th May 2023 are valid. Hold that the notification dated 3rd May 2023 enlarging the definition of relevant person under PMLA is not contravarious and are repugnant to the Constitution. Direction relief that the court may deem fit in the best interest of justice, fairness, equity, good conscience for this act of
Counsel for the petitioner seeks permission of the bench for rebuttal. There are only two main rebuttals. First is regarding the issue of Samir and Sohan. The counsel for the respondent stated that because Mr. Roy also responded, so there is a possibility of Samir and Sohan also being. So by this logic, any person charged of any offense before he could be detained, the government can just simply detain just because it is an apprehension that they may assault. Because the counsel for the petition, those submit that national security prevails over individual liberty, but
individual liberty still prevails over mere apprehension of the government that even if a person is charged of any offense, then they have a flight risk. So let's just arrest them immediately. The second and the last rebuttal is regarding the counsel for the respondents ultra-wise to the MOOT propositions arguments when they stated that they may have gotten the complaints when they were asked about the confidentiality from maybe their defense teams, maybe from their expert engineers, but this cannot be ascertained because this has not been brought to the public knowledge, not to the knowledge of the counsel for the petitioners, not to the knowledge of the honorable judiciary. Hence, the counsel for the petitioners put forth these two rebuttals. Thank you.
Answering question. Sorry, answer to the question about the possibility. While the jurisprudence itself that the court has to consider broad probability. It doesn't have to get the evidence. So whether the possibility of surveillance or screening exists, we are humbly submitting there exists possibility is based on because already one of the members has played, it's a right play. So there is a high probability these two people will also play. So this is not the only ground, it's one of the possibility. So I have not accepted this is the only ground. There are other multiple grounds that I have satisfied. The second issue is about the public knowledge and the contention I have made about the expert knowledge we have got from the channels. The law does not impose an obligation on us to say the reasons for give the evidence. On the contrary, the Rule 12 specifically mentions that the strict confidentiality has to be maintained because this is a matter of national interest and security of the state. So Yes, right.